Honorable, 90, if you make it even 60 days, it will not be stable until in December. So why don't you give them the time?
Motion.
Yes, Honorable nominated member.
Yeah. Honorable Speaker, I rise to move the motion that 90 days be granted for the report on the motion to establish a parliamentary inquiry into the petroleum product of 36,953.6 metric tons valued at $30 million.
Honorable members, any seconder? Yes, Honorable Member for parliamentary.
Thank you, Honorable Speaker. I rise to second the motion.
Members, it has been moved and seconded that effective today, 90-day period be given to the committee to submit its report. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Thank you very much, Honorable nominated member Keba. Honorable members, be resolved that this Honorable Assembly do ratify the motion to establish a parliamentary inquiry Honorable members, be resolved. Yes?
Speaker, but do you only need to thank the mover of the motion or the mover and the seconder? Thank you.
Where are you dosing, Honorable Member? That's what I did before I came out before I put the question. No, before that, I went up to the question when the Honorable nominated member interrupted. Probably you are thinking about consequence problems. Honorable members, be resolved that this August Assembly do adopt the motion to establish a parliamentary inquiry into the petroleum product of 36,953.614 metric tons, valued at $30 million US. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, may we proceed now?
Bills. Consideration stage of the Criminal Procedure Bill 2020 by the Honorable Attorney General and Minister for Justice.
Honorable members, you will recall that after the second reading stage, the bill automatically stood referred to the ABC committee. The bill is appointed today for consideration stage in accordance with Order 72 of the Standing Orders. During the consideration stage, members shall have the opportunity to give detailed consideration and scrutiny to every clause and schedule on the bill. At this stage also provides the first opportunity for amendments to the bill to be debated and voted on. I will now therefore resolve the Assembly to the Committee of the Whole Assembly to give consideration to the bill entitled the Criminal Procedure Bill 2020. The Assembly is now resolved into the Committee of the Whole Assembly. Honorable members, the Assembly will now go into the Committee of the Whole Assembly to consider the Criminal Procedure Bill 2020 clause by clause. We will be guided by Standing Order 72 during the consideration stage. Also, honorable members, we've already got the report from the committee. As we go through the bill clause by clause, the committee members, the chairperson of the committee, will try and guide us through the recommendations of the committees, as and when necessary. That's about okay. Honorable members, clerk, we can proceed.
Clause 1, subtitle.
It is proposed that clause 1, yes,
Yes, thank you, Chair. Clause 1, we want to change to 2024 now, instead of 2022 or 2023. Yeah. Yes, but we are now proposing to change to 2024.
Honorable members, Clause 1, Criminal Procedure Act 2024 instead of 2020. And wherever it appears, Honorable, huh? Because it will affect the whole subtitle here. It is proposed that Clause 1, subtitle, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 2, interpretation.
Honorable, we have 194A. You know, we've captured interpreter in 194A, and we want it to be interpreted in the interpretation part. So before we pass the interpretation, we want to propose that we add interpreter to be defined.
Clause 19.
We captured it into clause 19, but before we even get there, it's better we inform you so that we can include that in the interpretation part.
What do you want? What have you captured there?
Interpreter.
Interpreter
To be defined. Where is 1948? Yes. In 1948, it's saying an interpreter shall record and read over the statement to the suspect to his or her understanding.
Yes. So that you want that interpreter,
Yes.
to be interpreted. Yeah, yes.
Now I'm saying we want to do it now so that we don't pass the interpretation part. We go in and then when we want to bring you back, we know the chair always complains.
I agree with you. What we are now trying to, why do we have to interpret it? Does it interpreter mean something different, can mean something different?
To the interpreter. They've given a role to the interpreter and it has a context here. So we believe that it needs to be properly defined so that, it is clear what his role is.
May we invite the AG to help us with the legal document?
That's our recommendation.
Yes, AG.
Is the issue that the interpreter has not been defined and you want us to define it under the definition column? Yes. Oh, okay. All right. We wouldn't object to that. We can interpret an interpreter. What do we?
Problem actually is, interpreter can mean something different.
Especially in this context.
In the context here, you said, where a suspect does not understand, speak, or write in the English language, an interpreter shall record and read over the statement to the suspect to his or her understanding. Go further. The suspect shall endorse the statement as having been made by him or her, and the interpreter shall attest to the making of the statement. The interpreter shall endorse his or her name, address, occupation, description, or other particulars on the statement, The suspect referred to in subsection 1 shall also endorse the statement with his or her full particulars.
What we are saying is that it's not just the interpretation that you are thinking about, but it has a role. It looks like the role is getting bigger and bigger, so we want that definition to be put there. That's what we are saying.
No, but the role is stated by the bill itself. You are not talking about the interpreter. The bill is the bill that's talking about the role of that particular interpreter in this particular case. How are you going to define it?
Honorable Chair, the minister said they can easily interpret. Why don't you?
Yes, now I'm asking now, come out with a proposal.
That is our proposal. Let it be defined by the minister in the act.
Honorable Minister, how will you define it? How would you define it if you want it included in the interpretation column? Because if you define Honorable, my take is that if you define it, it must incorporate all what has been adduced to it by the distinct. And can you capture that in a definition? Yes, Attorney General, we are waiting on your proposed interpretation.
I'm consulting. I would propose we move, and then once, with the understanding that we will come back to this subsequently.
All right, honorable members, I will not put a question for interpretation. We'll come back on it. Yeah, we are suspending clause 2.
Yeah. Clause 3, trial of offences under Criminal Offences Act and other laws.
It is proposed that clause 3, trial of offences under Criminal Offences Act and other laws, stand part of the bill. The same? Honorable member, before I put the question, Honorable, immediately the clerk announces the subtitle. You can come up with your proposals. Please. It is proposed that clause 3, trial of offences under Criminal Offences Act and other laws, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 4, powers of High Court.
It is proposed that clause 4, powers of High Court, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 5, powers of subordinate courts.
It is proposed that clause 5, powers of subordinate courts, stand part of the bill. Woolley is, I said immediately after him. You don't need my permission. Go ahead.
Subordinate courts. The committee proposed that this clause stands part of the bill with the following amendments. 1. The committee recommends that 5.1 be added. 5.1. We need to add, we are saying the subordinate court may try any offense for which the penalty does not exceed 10 years. So what we are thinking about, what about life imprisonment and death? So we are saying we need to put except life imprisonment and death sentence to be added there before.
What we have now is a subordinate court may try any offense for which the penalty does not exceed 10 years. Does not exceed 10 years. So, death penalty has no, death penalty has, I think that one should be defined in another thing. Because death penalty, there is no There is no time frame.
It's okay, as drafted.
Probably you want to, what is the intent? What is your intent? What is the committee's intent?
We can skip that one. We can go to 5, we also have 5.3.
3?
Yes, and then we are recommending that we include the limit for fines. Limit for fines. For fines. You know, it's saying, subject to subsection 1, a subordinate court of the first class may pass any sentence for a period not exceeding 10 years. So what we have here in our recommendation is to include the limit for fines. Yeah, exactly. That's not there.
What his proposal is, 5.3 limits the subordinate courts to pass sentence not exceeding 10 years. Subordinate courts. What they are proposing is, yes, and fine also should not exceed a given amount. It means that fine should commensurate with the 10 years. If you can go about 10 years, and, pardon? You intend, they will come in, the legal minds will come in. Your intent is to put a limitation on the fines also. Yes.
We normally don't put limit to the fines because currently there is no limit to the fine. We only put monetary limitation in terms of the jurisdiction of the subordinate courts in respect of civil cases. But for criminal cases, the fines are left open. We don't cap it for them.
Their fear may be that where you limited them to maximum of 10 years, so, but they can still fine 10 billion.
Yeah, so long as the fine is reasonable and is within the context of the offense for which they find somebody guilty, they can impose.
Honorable, what he's saying is there is usually no time frame limitations to fines. Yes, go ahead.
Yes, and in clause 5, this clause 5.6. 5.6. The committee recommends that this clause be deleted as it can be abused by concerned authority. We are recommending that...
Is it 5.6?
5.6. The sixth one.
Yes, can you read it?
Where it is said the Chief Justice may grant a fiat to extend the jurisdiction of any particular magistrate, either generally or in relation to particular offense triable by the court of a class which may not be held by that magistrate. So we
read all.
Yes, and B, a magistrate whose jurisdiction has been so extended may pass sentences so authorized in such cases by law. So that part we need better explanation, but our suggestion is to delete it.
5.6. Section 5.6 to be deleted. That's your proposal. Honorable Attorney General.
I think this is useful. Generally, we created limitations for the jurisdiction of the subordinate courts, but we are giving the discretion to the Chief Justice, whereas some instances he could expand that jurisdiction either for specific situations or sometimes for a particular given case. For example, you may want to establish a specialized court, which is to be chaired or presided over by a magistrate. we have a general limitation as to jurisdiction of magistrate. But for that specialized court, the CJ might want to give them an expanded jurisdiction because that court will be looking at specific issues, which ordinarily a magistrate could not look at. But because of the specialized nature of the court, CJ might use his discretion and invoke and give them a fiat to look into certain issues that ordinarily a normal magistrate court would not look at. That's one scenario. Another scenario could be, even in the same normal magistrate courts, CJ might choose to allow them, for example, if their jurisdiction does not include trying, let's say, treason. Currently, they don't try treason. But this is a situation where CJ can give a fiat to a specific magistrate to proceed to preside and try treason. I'm just using that as an example. So those are the kind of scenarios we are looking at here. Exceptional situations where the CJ, with his best judgment, he could exercise and expand the jurisdiction.
Yeah, I think their fear, according to him, their fear is it could be abused. Meaning, of course, why don't you refer to the authorized, qualified judge? Hold on, please. I think that's your fear. Yes. If a magistrate is, before expanding his jurisdiction, why don't you give it to the judge or the category that has the jurisdiction to deal with it? Rather than allowing somebody to expand or to leave it that way. That's what their fear is. Have you heard him? You have heard him? Yes, let's hear from somebody else.
Chair, I think this clause needs to be maintained. The simple reason is that when you say jurisdiction of a magistrate, the jurisdiction should not be tied up. So, for example, if a case in Basse, do you understand? But the magistrate has a limitation to that case. The Chief Justice can grant him the go-ahead to make a trial on that particular case. So I think this cavity there, or this clause there, is very important. We cannot just try to close everything, tie it off.
Yeah, and that's what the Chief TJ said. But why not get the relevant authority to do the one being in the Basse?
Authority is the magistrate at the time, but the magistrate would not have the chance. But now is the Chief Justice that can give go ahead.
No, the magistrate does not have the chance. It's not that. It's that the magistrate does not have the authority.
Yes, the mandate.
Now give it to the magistrate who has the authority.
No.
Why do you need somebody to expand it?
No,
and the law is there that you are limited to this. You are limited to that.
Honorable Speaker,
you are limited to that. That's
have,
what they are asking.
Honorable Speaker, I have a clarification to make. I just looked at the text again with my people. It's about the class of magistrates, if you look at closely. It says the Chief Justice may grant a fiat to extend the jurisdiction of any particular magistrate, either generally or in relation to particular offense tribal by a court of a class. Now, magistrates are in classes, class 1, class 2, class 3. So this discretion will be exercised within that class, not outside of the class. So he could give, for example, a class 2 magistrate to preside over something that ordinarily a class 1 should have been presiding. So it's not to expand the magistrate court jurisdiction, but to deal with the jurisdiction within the classes of magistrates. In that regard, that is fine. So it's not to give the magistrate court what they don't have.
The fears.
Yeah.
Because if you bring a law to say that that's your category, why do you give individuals to change those categories as and when necessary? But if he's talking about a magistrate class 1, 2, 3, they are all magistrates, and therefore, depending on the circumstance, the TJ can allow magistrate class 2 to look over the issue of magistrate class 1, for instance. That looks a little bit more understanding. Yes,
you can look at this in the context of, for example, you have only a class 2 magistrate, say, in Upper River region. I may use Honorable's region. Only a class 2 magistrate is posted there. But a case happens which requires a class 1 magistrate to deal with. In that regard, CJ, if he trusts that class 2 magistrate can deal with the matter, he can give the class 2 fiat to deal with the matter. You understand? So there is a magistrate, but something emerged that ordinarily he was not the one that should handle that, or she. Then the CJ can give authority and say, proceed and deal with that matter. So that means by CJ's authority, he has given him permission to deal with the matter. Well, no, it's just to give them power to perform their duties in a different way. We give Fiat. I give Fiat to, for example, GRA lawyers to prosecute a case. They are not prosecutors. You can give Fiat, CJ can give Fiat to, say, a high court judge to sit at the Court of Appeal when the Court of Appeal cannot form a complete panel. Or he gives Fiat to a Court of Appeal judge to climb up and sit at the Supreme Court when there are shortage of judges. So these are the kind of things that we are saying. When the situation requires him to give a Fiat, he just give it to allow work to proceed. It's just operational.
Yeah.
Yes, nominated member Keba.
Yeah. Thank you, Chair. Chair, having listened to AG, I think the intent of Clause 6A and B is to expedite judicial proceedings. But again, listening to his explanation, saying that, a magistrate with a higher class can be given Fiat to preside on cases which might necessarily be done with another magistrate with a lower class. But if you compare that with the provisions of 6A, 6A is saying to extend the jurisdiction of any particular magistrate, either generally. Generally, it's not saying going up or going down, or in relation to particular offenses triable by a court of a class which may not be held by that magistrate. And it continues to be a magistrate whose jurisdiction has so been extended may pass sentences so authorized in such cases by law. My question here is, based on the text, it's not been specific. And what safeguards are there when Fiats are being given?
The Fiat itself will draw the lines. Fiat itself draws the line. So it tells you what you can do and what you cannot do and where your powers end. Because that Fiat is the authority. So it will tell you specifically what you are mandated to do.
But my only fear here is, if we really, prioritize speedy judicial processes over quality of judicial dispensation, at the end of the day, there might be backlashes. So how do we make sure that we have the necessary safeguards embedded in these provisions so that they would not be abused?
What I see here is, and I repeat, Honorable Speaker, this is just an operational issue, and we use it. Honorable CJ, even currently under the other legislations, he, like I said, he can designate judges and magistrates to do things that for example, a high court judge is not it cannot sit in an appellate court. But CJ can give you a fiat for you to go and complete a panel at the Court of Appeal. Court of Appeal judge can be given a fiat to go and sit at the Supreme Court to complete a panel if there is a shortage of manpower. This is normal. So for me, I'm seeing this as where you have a second-class magistrate, for example, as an example, who ordinarily will not be able to deal with arson. But if this second-class magistrate is the only one in a given jurisdiction, CJ can give him a fiat to hear and determine the arson case.
I think you said it. I now listen to honorable members. Yes, honorable. No,
just a question. Yes. AG, but I mean, like, will it be possible that a magistrate with a lower class be assigned a case that should necessarily be tried by a magistrate with a higher class, using the provisions of 6A?
That is possible, yes.
So now I'll come back to my initial question. The necessary safeguards, where do we have them in the law? So that at the end of the day, their fear can be allayed.
The actual safeguards is, I'm not too sure which safeguards you are particularly concerned, because sometimes these classes, currently now I don't think we even have any lay magistrates. All our magistrates are graduates of the law program. But their classes, sometimes their level of promotion is informed by either number of service or other issues. So, what is your concern that, for example, what should have been handled by a first-class magistrate, if you give it to a second-class magistrate, there is a risk? Is that the angle you're coming from, or what? I'm trying to still understand what your fear is.
Yeah, if you must put context to those classes, they are there for a reason. I might not know them, but I know their qualification matters. Qualification with regards to the, level of education, with regards to the number of years of experience you have and the cases you've handled. I might be wrong in it, but what I'm trying to say is the classes are there for a reason. It's not only magistrate class A, B, C, and D out of a vacuum. So, if at all, let's say A is the highest and B, you go down. A magistrate with class C obviously is lower than the magistrate having class A. Now, if you assign a magistrate with class C to a case that should be tried by a magistrate in class A, obviously, there's a potential. Because these cases, at the end of the day, is either material loss or the life of someone. This is the fear at the end of the day. This is the fear at the end of the day. So how sure are we that the necessary safeguards will be there when you are granting those fiats to magistrates with lower classes?
If I heard you well, you gave examples of, for instance, there is an incomplete appeals court, and then the CJ can use this provision. Yeah, a provision at least to elevate. Yes, to elevate. Yes, this is what I know. Where that exists, for them to want to be elevated to that place, to meet up the number. And also the appeals court also, where there is a shortfall, where the numbers are not met in the Supreme Court, can use similar caveats to replace them. Those exist. So why do you, if that exists and is going fine, why do you have to put this one down? That's where this thing is. Because it also means this is the only time.
The difference, Honorable Speaker, is those are panels. So that junior that you are co-opting into the senior panel, there are already senior panel members that are controlling the thing. Probably he is like, if it is Court of Appeal, you need a panel of 3. You have 2 Court of Appeal judges, but you are blessed with 1. You can bring 1 High Court judge to complete. It also serves as a training ground for them.
Yeah, but also he has the same equal votes as you have there.
Of course, yes.
Yes. So what we are saying is where it exists there.
Yeah.
I see no objection why it cannot exist
in the subordinate court. I have to recognize the fears of the committee and those who have been speaking is genuine. But this also is important. We are looking at scenarios where a situation arises, even where it is, for example, a first-class magistrate that should handle it, but there is no first-class magistrate available. There is a second-class magistrate at hand. Would you have to abandon job completely because there is no first-class present? For me, I can equate this, for example, where the law says a particular, let's just, for sake of example, if a particular offense is committed, only an inspector in the police can arrest. This provision, in my view, if I want to equate it in that, I'm saying we are giving power to IGP to say where an inspector is not available, he can authorize a sergeant to arrest. Just those kind of scenarios where the law says this particular kind of offenses can only be tried by first-class magistrate. But a situation arises, there is no first-class magistrate at hand. And, for example, somebody have to be charged, for example, within 72 hours. Somebody is arrested probably charged with arson, like I said. And there's no first-class magistrate, but there is a second-class magistrate sitting. Why would not CJ give a Fiat to the second-class magistrate to hear, at least take the pleas, even if he's not going to proceed with the charge, but that at least he will have the jurisdiction to take the pleas, maybe then refer it to another court. You see the point? But otherwise, if you don't give the CJ the authority to expand the jurisdiction of magistrate, that means each magistrate can deal with only your authorized substantive jurisdiction. So if something arises where you need to go a little bit outside, it becomes a problem.
I think the reason of having this particular clause, as I said, for example, we have a lot of cases in the courts. So it's going to reduce the burdens on the courts. Because there are certain cases, if you leave the law as it is, you don't have this thing in place, it means a first-class magistrate should sit on that case. When there is a second-class magistrate who can take care of the case. So the other issues will be in the regulations. The fear that is put by members will be in the regulation. So I believe this thing is very important because our courts are congested with cases that you don't have a specific magistrate you cannot try.
Honorable member for Wool East.
No, Chair, what is here is to extend jurisdiction of a magistrate. It's not the one who is a higher class. You don't bring that one down. You don't bring that one down. But the one who is down, a lower class, is the one you extend. That's what is here. It's not what he is saying.
That's what he said.
Yes.
I'm saying
He's saying that magistrate class 1 to deal with a particular situation, and that there is no magistrate class 1 there. And now there is a magistrate class 2. The CJA could use this clause to ask that magistrate to deal with that issue. If the CJA is convinced that that magistrate is qualified enough to deal with it. We count on discretions. Even us here, we are here to make laws for the Gambian people. The laws we make it for the Gambian people, but we express our minds and then we make decisions on our own. Yes? Yes, Honorable Nominated Member.
Honorable Speaker, we do agree with AG, but we believe the Fiat itself is self-regulation. So, does it make any harm if you go, for example, 6B, you say a magistrate whose jurisdiction has been so extended may pass judgment so authorized in such cases by law, then you have, just bring in a safeguard to make sure that this magistrate, the case he will be trying, the extended jurisdiction he is qualified to sit on that seat because he has such experience or what. You are the legally minded people, and I know you know what we are trying to say. So that at the end of the day, whosoever will be given the Fiat will be cognizant of those facts. But if you leave it like this, it's like a blank check.
Honorable, for instance, the court, you have the High Court judge sitting, or a judge sitting over. He listens to both sides of this thing, all these things, and he makes a judgment. He makes a judgment from his own perspective. Probably a different judge may give a different judgment. But you take that judgment, if you are not satisfied, you appeal against that judgment. So in this particular issue, I think what the onus is now on the CJ to try of course, the trust in the CJ to ensure that whoever is given those powers is qualified enough and is done in a way that justice is done. I think that's what is there. But it may be difficult to capture all that on a bill. To put all those things in a bill may not, it will be difficult. Probably in regulations or whatever you may want to put it, but not on a bill. Thoroughly. Yes, that's why it's good. You see, discussions encourage, it gives more power, more information, and then people get convinced. Time is of essence only, not at the detriment of.
Okay, no, we'll concede, because that's the way they operate. It looks like that's the way they operate, so we just concede.
It is proposed that clause 5, powers of subordinate courts, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 6. Sentences in case of conviction of several offenses at one trial.
It is proposed that clause 6, sentences in case of conviction of several offenses at one trial, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 7. Arrest generally.
Yes, go ahead.
Yes, Honorable Chair, clause 7, we just want something to be added there. The committee recommends that we need to add within 3 hours of arrest, the person who is arrested or detained shall be informed as to the reasons of his or her arrest or detention.
Can you read what is there now?
To be added there. What is there is a suspect or accused person alleged or charged with committing an offense established by law shall be arrested, investigated, inquired into, tried, or dealt with according to the provisions of this Act, except otherwise provided under this Act. No, we have not the charges.
Total is number 9, not 7. It's part 3, but number 9. Am I right? Look at it.
Yes, notification.
Okay.
Yeah.
Sorry.
It is proposed that clause 7, arrest generally, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 8, mode of arrest.
It is proposed that clause 8, Mode of arrest.
Speaker, observation.
Start.
Chair. Oh, I should allow you to.
No. I have said if you have objections after the clerks mention it, just before I come in, you let us know. What do you want?
Either the mover or the minister to make a clarification, whether it's ideal for us to have the person who is under arrest, his liberty and rights should be guaranteed. Because sometimes you go and arrest people.
Where are you making
9 on the 8 mode of arrest.
Where?
I said, can we add that clause there? Like you go and arrest people at the end
This is mode of arrest.
Yes. The man, I think the mode is about.
Yes. How can we prevent that?
People's privacy should be respected during the arrest. Right to. You cannot. Go and arrest me in my home.
That's the law.
Can't say.
No. You see, you are talking about privacy. The whole thing is people don't come and jump. When they want me, they will tell me you are under arrest. I said I submit myself. No problem. You go.
In Nauleri village, in my constituency, they went to arrest somebody and he gave himself all the mobile phones in the house. We are confiscated. We are taking
Until that happened.
They still.
Who stole it?
So there should be a regulation.
No, but they are honorable. This is a law. There are regulations at the police and other these things, other subsidiary laws.
Are you alleging or you have evidence? Are you alleging or evidence?
Loss of mobiles, etc. You know what I'm trying to say here is they are already. It's not limited to this. There are already existing legislation and regulations guiding these things. Yes. I know what prompts most of these things is the police may unlawfully arrest you. It can happen. They are human beings. But when you are on the arrest, just submit yourself. If you know you are innocent, just submit yourself. Go. He will not just do what he wants to do with you. He has to follow the laws. He's saying that we should add clauses to protect right of privacy. What is right of privacy during arrest? That's what I don't understand.
Chairman, once you are alleged of a crime and you are to be arrested, you don't have a privacy.
No.
You have no privacy. You are supposed to be arrested. You are notified that you are under arrest. Give yourself up. You have no privacy. You have no.
Honorable, no. If I give up myself,
Chair.
should you touch my properties in my house? This is what I'm saying. We have been seeing it.
Honorable, if your properties are touched,
If they are linked, yes.
no.
Right. For example, you are suspected of something, and that is linked to the mobiles. They will collect all the mobile phones.
You have a right to redress. So you can use those sections and get redress.
Chairman, Chair.
What has happened?
Chair, his fears are already addressed in clause 9. Yes, good.
Perspective of central body alone. Yes, but I know. What I'm saying is, where police may abuse their own powers. It's possible. But you also have right to redress, also means also to do that, to address those things. It is proposed that clause 8, mode of arrest stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 9. Notification of cause of arrest and rights of suspects.
All right, honorable member for Central Body. Look at the very clause 8. 2. If the person subject to an arrest forcefully resist the endeavor to arrest him or her, or attempts to evade the arrest, the police officer or other person may use reasonable means necessary to effect the arrest. This is what I was explaining to you. If you are doing this way, they will do more that way, so that they will get it. All those things are subject to these things. When you are under arrest, you have your freedom, and you are under arrest. What freedom do you have? You don't have that freedom again. Why are you sent to prison? That is, but the Constitution said you have a freedom, and you can only be proven beyond reasonable doubt without a process. A process has to be followed. Yes. So, clause 9. Yes?
Yes, the committee recommends that we add within 3 hours to 91C. 91C. At the end of the sentence.
Can you read it?
91C.
Except when
the suspect has escaped from lawful custody, the police officer or other persons making the arrest shall inform the suspect immediately of the reason for the arrest. So immediately to be qualified. We want to say, instead of immediately, within 3 hours. Instead of saying immediately, because what is immediately?
Within 3 hours.
That's a constitutional requirement, yes.
No, that 3 hours?
Within 3 hours.
Yeah, but if it is a constitutional requirement, the Constitution supersedes this one. So,
I believe, Honorable Speaker, this is even more friendly than 3 hours. For me, if you ask me, immediately means immediately. So the Constitution says within 3 hours.
No, but you have not defined immediately.
Well, sir, immediately, we give it a reasonable man interpretation.
Yes, immediately can mean, circumstances can come where immediately may mean 1 second, it can mean 5 minutes, it may mean 20 minutes. It's circumstances. So put out all doubt, this one is within.
Well, the Constitution have guaranteed that.
Huh?
The Constitution have guaranteed the 3 hours.
The 3 hours?
Yes.
Then that's fine. But what I think what they want is to bring it down to this clause also, to remind them.
Chair.
Is that, just hold on. Is that okay? Is that okay? Is that possible?
It's a fundamental right issue, and it's guaranteed by the Constitution that you should be notified of the reason of your arrest within 3 hours.
Yeah. What I'm saying is it correct to bring it down as a notification to people here?
Well, makes no harm. But like you yourself said, it's guaranteed by a super law, a law that is higher than this one already.
Okay. Yes, but
you know, the reason why I go in for immediately. Immediately is within that 3 hours. The simple reason is saying that when you say immediately, it's possible. So if you say only 3 hours, the police in charge can abuse it and wait until 2-3 hours and say, now you go. So, but immediately here is emphasizing that, you know, it has to be explained in the language that the person understands.
Yeah, immediately, what does it mean? Is it 2 minutes?
Immediately.
Second?
How soon? The soonest.
Yes, how? When is that soonest?
Yes, that soonest. It is going to be determined by the circumstances.
This one we are saying now, this one we are saying, we don't want
but
to
it's not bad to leave it there.
No, listen. You also listen. The proposal is not to exceed 3 hours. It can be 1 second, 10 seconds, for whatever reason, it cannot exceed that amount. That's what they are saying. So immediately is a vague term in terms of. honorable members, I think the committee, all what they want to do is to safeguard the accused. And what these legal people are telling me now, yes, so far that is a constitutional provision. Whether it is here or not, that should apply. So, but immediately could mean, at the time even where you are arrested, before you are taken, you should be told. But if you say within 3 hours, they can pick you from there, take you up to the place, so far it's within the 3 hours ambit, and then they begin to talk to you. So, but this immediately you can be argued to mean that immediately you have arrested him, you tell him why he is arrested. So that caveat that you are talking about is already in existence. That one, you cannot escape. Whatever you do, whatever excuse is not be more than 3 hours. So if they use a term that can mean less than 3 hours, let's agree to that.
By implementing this, are not looking at your constitution. This is what they are looking at. This is what they are looking at. This is what they are used to.
Yes, this is what I'm saying.
So whatever you put here is what they are going to use.
No, their training should surpass that. That they know that there is a supreme law.
No.
You cannot be a police officer, you don't know there is a supreme law that overrides all your laws. And two, the other thing is, that clause is, whether it's captured here or not, it means it's there. 3 hours. But this immediately, it can...
Immediate, now, when the constitution is there, I can always say, no, the constitution says 3 hours.
3 hours. But you can do it below the constitution. What the constitution is guaranteeing is, it should not be more than 3 hours. But there can be a law to say it can be 2 hours, it can be 1 hour, it can be 30 minutes. But you cannot make a law to say it can be more than 3 hours. So this one is telling you immediately now. Tell him. No, don't talk about voting, my friend. You don't have, no, we need to talk to each other. No, it's not like you. You don't agree, usually agree, you just spin up. But Swaibu listens and he agrees. No, he's not wasting time. He wants to be clear. Please.
Bintang, thank you. I think nobody can put it better than you did. Because this one is talking about clearly 3 hours. And this one is saying immediately. So it's emphasizing and putting more emphasis on the law. So, and how you put it exactly, I am part of the committee, but you have put it in a better way. Then let us go by immediately. That is fine.
On clause 9. No, in many cases, you have different opinions, and we inform each other better. We don't want people to hear other views and then go to vote. Somebody will vote because he is not informed. Make sure that everybody is informed, and then you ask for a vote. If you are tired, park and go back to central body. Sign.
Yeah, put the vote. 9.
It is proposed that clause 9, notification of cause of arrest and rights of suspect, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. We have no amendment.
Clause 10, notification to family of arrested person.
It is proposed that clause 10, notification to family of arrested person, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 11, notification of substance of arrest. Warrant, sorry.
It is proposed that notification of substance of warrant stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 12, search of place entered by person sought to be arrested.
It is proposed that Clause 12, search of place entered by persons sought to be arrested, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 13, power to break out of house, etc., for purposes of liberation.
It is proposed that Clause 13, power to break out of house, etc., for purposes of liberation, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. But what does that mean? Yes, it's our own. We will be seeing it. No, I don't understand power to break out of house.
Speaker, this is a situation where the police enters a house or an enclosure lawfully. For example, in a situation of rescuing a hostage, one scenario could be a situation where somebody is detained and they have to escape, because it says the police officer or other person authorized to make an arrest may break out of any house or place in order to liberate himself, if the police officer himself or any other person who, having lawfully entered for the purpose of making an arrest, is detained therein. So if you enter to effect an arrest, maybe the person you want to arrest managed to detain you, capture you there. So you are given authority now to force your way out, even if it means breaking.
Explain it better for
Is
you
it
to
prohibited
understand.
tongue?
Yes.
Yes.
I wanted to explain it better for you to understand. In an event you enter to arrest someone, not knowing that the individual is outside. As you enter, the individual lock the door behind. Then you are there and you want to escape. Therein you can be able to break out and come out. That is what it's exactly talking about. Yes.
That's a good one.
Clause. It is, yeah, clause 14.
Clause 14, no unnecessary restraint.
It is proposed that clause 14, no unnecessary restraint, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 15, search of arrested persons.
It is proposed that clause 15, search of arrested persons, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 16, examination of arrested suspect.
It is, yes.
Yes. Yes, the committee recommends that sub C be added to cover the exemption of DNA testing to be subjected by the court order. That is, when you read up to, you have...
Can you read the whole thing?
Yeah, I see out of it.
Yeah.
But, okay. Examination of arrested suspect. While a suspect is in lawful custody on a charge of committing an offense of such a nature and alleged to have been committed in such circumstances that there are reasonable grounds for believing that an examination of his or her person will afford evidence as to the commission of the offense. A qualified medical practitioner, or B, any certified professional with relevant skills acting at the request of a police officer may make such an examination of the suspect in custody as is reasonably necessary in order to ascertain the facts which may afford the evidence, and to use such force as is reasonably necessary for that purpose. So we were thinking that there may be a need for DNA test. So if there is going to be needed, then a court should order for such a test. If we can capture that in the, that's what we are.
No, but this one I think you are talking about. You are talking about some different things. This examination of an arrested person, suspect, this is to reduce evidence And two, if you talk about a qualified medical practitioner, I mean, the various tests they will use, the various things they will use can include a DNA. If you talk about DNA in this one, then you have to name all other means of doing it.
Chair, that could come under 18 and 19, where you have recorded.
Honorable Member Woolley, you are now in agreement. You know, why do you have to specifically talk about DNA? Yeah. Because if you talk about DNA, you talk about other methods also, other tests, whatever. But is DNA the only type of test? Are we talking about the most advanced types of tests? No, you have to be with us. You are not there. Be with us. Please. Honorable, can we get around this?
No, I think the mind of the members was that DNA test should be exempted.
Should be exempted?
Yes, and if they want to conduct it, it means that the court should make an order for it.
But there is no, this place is not for exemption.
What is this talking about?
This one is not talking about exemptions.
Examination.
A qualified medical practitioner or a certified professional to do the examination. So it is open to do any examination. So we are asking for an exemption of DNA testing. If that is going to happen, then the court should order for that. That's what we are suggesting. You understand what I'm saying now?
Now, yes, you are trying to limit the qualified medical practitioner. That is, whatever test he may do, he should accept DNA. That's what you're talking about. Am I right?
The qualified medical practitioner will do all tests, all type of tests.
Except DNA.
But we are saying we should qualify that it should be except DNA testing. And if DNA testing is going to take place, then...
Honorable, I think you are making me repeat and repeat. You are not listening to me. You know, you just want to say what you want to say. I am saying exactly what you are saying. You are now saying we limit the qualified medical practitioner from, he can do all tests except DNA. And that DNA, if it's to be done, it should be ordered by a court. This is what you are saying.
Chair, we are conceding that my honorable friend is saying all these tests are ordered by the court anyway. So if that is the case, then we are conceding.
Yeah, but when you are making suggestions, open up. You listen to various ideas. Don't hold on to it so strongly. It is proposed that clause 16, examination of arrested suspects, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 17. Arrest persons to be taken at once to a police station.
It is? Yes.
And B is where we have our recommendation. The committee recommends to add 3 hours to without delay.
Honorable, when you are making these proposals, you must read for members to understand, and then they will see the logic of your explanation.
No, they should go straight to 1B, 17.1b. If they go to 17.1b, they will see.
You first of all have to read 17.1. Okay, a person who is arrested with or without a warrant shall. Yes. Then B, what? Shall without delay
shall be taken with all reasonable dispatch to a police station or other place for the reception of arrested persons. And B is where our problem. B, without delay, be informed of the charge against him or her. So it comes to the same thing. The without delay is where we want to qualify it to say within 3 hours. Within 3 hours. Not without delay. It's the same, it's the same.
The 3 hours you are talking about can never be removed except at, when the Constitution is amended. And any law contrary to that, you are no more. So what this be, this gives the opportunity for accused persons also to push hard without delay. Without delay means immediately. It not even qualify, it not say without undue delay. But it said without delay. Immediate.
That the police also have their rights.
Yes, they have their right, but the right does not mean that you cannot tell the individual those things. No, there is no quarrel. My friend, you arrested, why will you arrest me? You must have known it. Even that second, you should be able to tell me, you are arrested because of A, B, and C. Whether it is true or not is another thing. It is proposed that clause 17, arrested persons to be taken at once to a police station, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 18, recording of arrest.
It is proposed that clause 18, recording of arrest, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 19, recording of a statement of a suspect.
It is proposed that clause 19, recording of a statement of a suspect, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 20, prohibition of arrest in league.
It is proposed that clause 20, prohibition of arrest in lieu, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 21, human treatment of arrested person.
Mr. Speaker.
Yes.
Your indulgence, I think we've moved faster, it escaped me. The interpretation that was proposed earlier, which was on the 19, we've got a proposal for having an interpretation or a definition of an interpreter for the context of 19. We are finding it difficult to get a general interpretation because interpreters are used differently. The interpreters used in the courts, interpreters that are used in the station. For this one, we are offered a proposal for defining that. If we can insert it on the 19 with your permission. I know we passed it already, Honorable Speaker. If this is possible. If not, we can go to the end as believed, then we can come back to it.
No, we can go back and then rescind our
propose that we leave that until later.
Yes.
That means that we've already accepted that we can always go back.
Okay.
Yes.
Okay, so we are proposing a clause 7 after subparagraph 6. 19 have subparagraphs up to 6. So we are proposing an insertion of a 7, which will read, in this section, an interpreter is a person proficient in both English and the suspect's native language, who translates the suspect's statement and ensures their understanding and affirmation of the statement. In this section, an interpreter is a person proficient in both English and interpreter in quote. Yes, is a person proficient in both English and the suspect's native language, or any other language the suspect understands, who translates the suspect's statement and ensures their understanding and affirmation of the statement. Who translates the suspect's statement and ensures their understanding and affirmation of the statement. So that's the role of the interpreter in this section. Understanding and affirmation of the statement, full stop. So I read again, in this section, comma, an interpreter is a person proficient in both English and the suspect's native language or any other language the suspect understands, who translates the suspect's statement and ensures their understanding and affirmation of the statement. Yes.
Put it to a vote. Yes, we need to open it up. Woolly East, open it up. Clause 19.
What's the definition of interpreter?
We had already taken a vote on it.
No, not yet.
We have.
You have to read it to people, to members,
I mean, we already took a vote on it. We read recording of a statement of a suspect, and then I put a question, and then everybody agrees as it is. Now we want to go back and amend it. So we have to revoke that decision. Rescind that decision now. Move the motion, Honorable Member for Woolly.
Okay, we are, Honorable Chair, moving that we rescind our earlier decision and on 19.4a.
No, on clause 19.
Clause 19.
Yeah.
To include the definition of interpreter.
No, we just rescind the decision.
I move that we rescind the decision on clause 19.
Yeah. Any seconder? It's moved and seconded that the decision taken on clause 19 be rescinded. Those in favor, please say aye. Not in favor, please say no. So the decision is rescinded. Now the new proposal. It is proposed that clause 19, a recording of a statement of a suspect, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. The relevant proposed amendment is already captured. The table office will deal with it. And the office of the clerk. Yes. You want to read it? Yeah, but the minister read it about 5 times. Yes, we are now on 21.
Clause 21, humane treatment of arrested person.
It is proposed that clause 21, humane treatment of arrested persons, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Part 1, clause 22, arrest by a police officer without warrant.
Go ahead.
Clause 22, we have a correction at H, 22H, where it reads, You have to read the whole thing. H is saying whom he or she suspects on reasonable grounds.
Equally honorable members.
No, let's start with.
Yes, a police
officer may, without an order from a magistrate and without a warrant, arrest any person, H, whom he or she suspects on reasonable grounds of having been concerned in any act committed at any place out of the Gambia, which, if committed in the Gambia, would have been punishable as an offense, and for which he or she is under the Extradition Act. So the off there, the off after the act, we want to change that to or otherwise liable to be apprehended and detained in the Gambia. We just want to change off to O.
It's okay, Honorable Speaker, yes. I think it's a typo.
So, honorable members, the off should be OR. Any more on that page, on clause 22? It is proposed that clause 22, arrest by police officer without warrant, stand part of the bill as amended. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 23, arrest of vagabonds, etc.
You have something?
Yes, Chair. The committee, the clause is 23, arrest of vagabonds afford reason to believe that he or she is taking such precautions with a view to committing a cognizable offense. And B, within the limits of the station, who cannot give a satisfactory account of himself or herself.
But are those vagabonds? Someone found taking precautions to conceal his or her presence within the limits of the station. You cannot call him a vagabond. Then everybody is a vagabond. Who is, if you are this thing? Yeah. Yes, anybody assumed to be doing something bad, then you are a vagabond. Because this is what it implies. You are in a station. You see you see somebody around. You tend to believe that the person is hiding or doing something because he may have criminal intent. That's what they are talking about. And all other arrests that you have been doing, whether it's at the station or there, they are all the same. Reasonably believe, yes. When they see you, yes.
You know, this law comes from, we know when this law comes. It comes at a time when they feel that there are people who are useless, who have nothing to do, and they are just loitering. And, you know, they suspect them for being loitering, you know, etc. And then they just say they are vagabonds because they are not being busy, reasonably busy on anything. So that's the word vagabond. So the issue is after that word. It's a colonial culture.
Where the heading is not probably captured. It's not captured correctly. Yeah, arrest of vagabonds. Probably that's not the correct terminology, but he said, cause to be arrested any person found taking precautions to conceal his or her presence. Whether you are not, even if you are not a vagabond, you may be a lifelong criminal yourself. You are doing those things to come and do criminal activity. You may not be a vagabond. Yes, but this is what the law is good. But the heading is what I think it is wrong. Vagabond, arresting vagabonds. And only vagabonds who do that. Criminals themselves do it. Criminals. So if the person is a criminal, you cannot arrest him. No, but a vagabond, if the person now is a vagabond, for instance, but he is here taking precautions to conceal himself. Remember that, that's it, within the limits of the station. Under the circumstances which afford reason to believe that he or she is taking precautions with a view to committing a recognizable offense. Whether you are a vagabond or not a vagabond, you will be arrested. I cannot match the two now. Yes, Honorable nominated member.
Chair,
Serekunda, sorry,
yes,
Serekunda.
Chair, I think you've almost agreed with us. The issue is with the word vagabond. And now you confirm that maybe the problem is with the word vagabond. But if the person has a criminal intent, of course the police has all rights to arrest the person. But the issue here is the vagabond. So you agree with us. So
the difference with you now is, why arrest of vagabonds? Yes?
Chair, that is why we are saying we want to delete it. There's no
Want to delete vagabond?
Yes, we want to delete the entire clause.
No, what about a criminal who has that intent to go there and do that?
That is a criminal is in all the sections that criminal procedure bill should be arrested wherever they are found. But for vagabonds, they should not be arrested. That's exactly what we are talking about.
Tell me, I don't know a vagabond. A person?
A vagabond. Chair.
No. What is vagabond is an English word. What is the meaning?
I'll tell you the meaning.
Yes?
It's a person who goes around wandering, thinking about things. That's what we refer to as vagabond. You are wandering, you are just going in isolation, thinking about issues, just wandering around. It's what we refer to as vagabond.
Criminal activity. You should be arrested.
Yes, but that one now is a criminal because with the intent.
But it's a vagabond can be a criminal.
But how do you ascertain that?
A vagabond can be a criminal.
Yes.
Yes.
That is, Chair.
Somebody who has just been loitering, going about thinking and loitering, can turn up to be doing some criminal activity.
Well, we agree, Chair. But until proven, you understand, or until suspected.
This is what he's saying here, that you are suspected and reasonably believe that you are hiding or concealing yourself with intent to do criminal activity. This is what he's saying.
Yeah, you have a point. Let me check again.
You see, this comes from the English people. At a time when they feel that we have a lot of people, young people, poor people who are moving about, mainly poor people, who do not have work and they don't have a station, so they keep on wandering about. So when they see them, they used to arrest them and put a mark on them, so that everybody will know that this one is a vagabond. Wherever you should see him, you should arrest him so that you take him to go and do some work for you in one place or the other. So that's why this law was there. Now, whoever commits anything which is a crime is a criminal. We don't need to call people vagabond. So that's why we want to remove that there. So that it applies to everybody.
You are informed by the colonial relics. But this one, is qualified. Say somebody found loitering in the station, who is a vagabond, just loitering. No, you cannot arrest that vagabond. But with intent to offend a crime, you have. Now, this is what I'm saying. Here, the problem here is, Honorable, a vagabond is not a criminal. It's somebody who is just loitering, thinking about things, taking precautions to conceal his or her presence so that people will not see you. within the limits of the station, under circumstances which afford reason to believe that he or she is taking such precautions with a view to committing a recognizable offense. So that one is definitely to be arrested.
We can propose a change of the heading.
Yeah. The change of the heading.
So we can propose arrest of suspect. You must be idling in such a way that you are even concealing your presence there. So, with that, definitely, I don't think you are right. Vagabond may not be the right heading. So we can change the heading.
Are we removing vagabond?
Just the headings.
Vagabond is not thinking, going about, hiding themselves, and there are reasonable reason to believe that the person is out to commit an offense, should be arrested. Probably you are doing that to go and set a place to put fire somewhere and then go out, or to do some other things. You should be arrested. That's why the vagabond now is no more there, and then it's arrest of persons engaged in suspicious behavior. And this is limited to the station, to the police station.
Talking about the perimeter of the station. Around 3 o'clock, they found a boy somewhere in the night who cannot explain himself. And even if you look at of the station, the limit.
I agree with you, but we should recoin it to mean within the jurisdiction of the area covered by the station. But if you talk about the station, a station is the police station. You know, you should be able to coin it in a way that you are not limiting to the police station, but you are yes, please. Yes, Kiam.
Honorable Chair, but the police stations have a limit beyond which
if you want this thing to mean the jurisdiction, you must interpret it to mean that way.
Well, yeah, the intention of these drafters is to arrest vagabonds for other reason, for a criminal offense, and they arrest them. We should just delete this section because their intention is to follow vagabonds. That's all. All other criminals can be arrested anyhow.
That is the intention. We are now saying that that should not be the intention.
According to the interpretation of police station, the use of the limit of station is correct according to the interpretation. Post or place appointed by the Inspector General of Police to be a police station, or the office of the superintendent or assistant superintendent, and includes the area policed from such a station. The area. Including the area.
Yeah. Then that's fine. In the absence of an interpretation, you have to recoil it. If it is interpreted to mean that, then we are fine. Yeah.
Chair, I think we should leave the vagabond there because in our, of course. You have a lot of vagabonds roaming around the streets there, and you have such persons within our community.
Honorable, if those people are found, whether you are vagabond or not, and you have that criminal intent, you will be arrested. There may be vagabonds who are not criminals, they should not be arrested. But if you have that criminal intent, you are going to be arrested, whether you are vagabond or not vagabond. That's what it is there. Honorable members, it is proposed that clause 23, arrest of persons engaged in suspicious behavior, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 24, procedure when officer in charge.
Procedure when officer in charge of police officer deputes subordinate to arrest without warrant. Procedure when officer in charge of police officer. Honorable, help us with that heading. Officer in charge of police station.
Officer in charge of the police.
Of police officer, instead of police officer, any more proposals on that? It is proposed that clause 24, procedure when officer in charge of police officer deputes subordinate to arrest without warrant, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 25, refusal to give name and resident.
Just hold on. Member for Woolly East.
25(3). Sorority or sorority. Sorority is resident. Sorry. So we just want to change the sorority to sororities. To sororities. Secured by sorority. A sorority or sororities. You can have one sorority, you may have two sororities. And so on, isn't it? So we just want to change the second sorority to sororities. You've seen it?
Yes, I have seen it. I just don't understand. The first sorority is by a sorority or...
You know, sometimes they may ask for two sororities or three sororities.
And what do you want put there?
No, we say secured by a sorority or sororities.
Spell it.
One or many.
That's the spelling. It came from TY to TIES, no apostrophe. No. Yes, that's plural. That's yes. No need for apostrophe.
No, I'm not convinced, Chair.
Yeah, but honestly, that's correct. You go anywhere, that's the language. You know, you will not find anything like that. TIES and you have an apostrophe S. You will never see it. Wherever you see it, tell them that it is wrong. Be bold, it is wrong. Not the Shakespearean English.
For 25(4)A. The committee recommends that the second A be changed to B. It's just this thing. You know, we already have A, we should have B instead of AA. Huh? You've seen it? Yes, and then also 25(4), we're saying the committee recommends that the word magistrate in the last sentence in the clause to be changed to courts instead of magistrate, so that it is read, he or she shall forthwith be taken before the nearest court having jurisdiction. You've seen it?
Yes, Honorable AG. Instead of the nearest magistrate, or it's saying the nearest court. The nearest court can be the Supreme Court. It can be a magistrate court. It can be that court. Yeah, but do they? Hopefully, I think they may want it to be probably at a magistrate court. Yes, that's why they put.
Or there are instances, even sometimes you approach magistrates for certain, they can do signing a warrant, for example, signing a post-mortem request. So I think we since this is about the identity of the person, it's about him providing arrest in the event where the true name or residence of the person is not disclosed. So they can approach a magistrate even during the weekend. In that regard, if you insist to make it court, it has to be a court. But they cannot meet a magistrate even outside of normal conventional court where he could sign certain things, probably. So I believe there is a reason why we use magistrate instead of court.
Member for Wuli, are you convinced equally?
No, this is taking a person too. Somebody is taking you. He or she shall forthwith be taken. The person is not going by his own discretion. Somebody is taking.
Going to be taken before a magistrate. As long as the person is a magistrate, that is fine. It doesn't necessarily have to be a court. Sometimes we pursue magistrates for them to sign certain documents, and we meet them any place and they sign, not necessarily in a courtroom.
Just like when you get your forms and it should be signed by an MP. You may not be in Parliament to sign it. It may be probably in your house. Suppose that clause 25, refusal to give name and residence, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. Who is saying no? The ayes have it. We are past. If you want to know the number, that's what you can do. The ayes have it. I've already decided. What do you want? Do you want to propose an amendment? Pardon?
Clause 26, arrest by private person.
It is proposed that clause 26, arrest by private person, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 27, arrest of suspect doing damage to public property.
It is proposed that clause 27, arrest of suspect doing damage to public property, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 28, arrest by owners of property.
It is proposed that clause 28, arrest by owners of property, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 29, disposal of person arrested by private person.
It is proposed that clause 29, disposal.
Means to hand over to the police station. The nearest police station.
Person stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it. Somebody arrested you in his property. He is disposing you. It can mean something.
Little issue. Chair, 30, we have issue with 30 sub 4. Sub 4, we want to You've seen it. We want to delete the word time is mentioned twice, so we want to remove the other time.
You read the whole thing.
So I will read to be able to read like this. Where the person taken into custody is detained in custody, he or she shall be brought before a subordinate court at the earliest time practicable time. You see, if mentioned time twice. And in any case, not later than, then it continues. So we want to remove subordinate and just maintain court. And then, yes, and we want to remove time. So that it will read like this now. Where the completed. That's how we want it to be read. Yes, instead of subordinate, we want to put competent, and remove instead of doubling the time, we just remove one time. You've seen it.
Yes, but you talked about 24. There is no 24 here, not later than 72 hours. Is what is there. And you talked about 24. Yes, you said 24. Two remain. So your is to change subordinate court, the subordinate to competent court, and then practicable time, the time be removed. Huh? So, Honorable Attorney General, instead of before a subordinate court, they're talking about before a competent court.
We would want to retain subordinate. We have a reason. We do not have sufficient number of high courts across the country. So if you use the word competent, it means it has to go to the court that has jurisdiction to try the matter. And that is going to make law enforcement very difficult. Because if you arrest somebody for offenses that are only triable in the high court, the competent court is only the high court. So that means you cannot arraign them within 72 hours, because the nearest court to you is a subordinate court. So we normally take them there, take the police, arraign them, and then transfer it to the high court. So if you insist on using competent, it will be very difficult for law enforcement.
But in all the regions now.
Yeah, but high courts, even not all the regions, but even if they're in all the regions, they are only at the regional capitals. There could be situations high court only sits in Janjambure and not every day. So we believe for efficiency and making law enforcement more effective, they can arraign them before a court, even if that court doesn't have jurisdiction to proceed with the trial, but they can take the preliminary matters and then forward the case.
Honorable, I think we still have some clouds around. Sometimes accused persons are taken to the magistrate to be remanded. And it is mandatory that usually magistrates, by law itself, they shall remand. They will remand. Whereas when it is at the competent court may not remand, because they have competent jurisdiction to look at the issue and make a determination. But at the magistrate court, the only thing he can do is to remand. Yes, what can he do? He cannot deal with the case. The bail, this is what I'm saying. He will not be able to release you. You are accused for something else.
Honorable Speaker,
so why not take the person to the competent court instead of the magistrate, the subordinate court?
Honorable Speaker, I owe you a correction here.
Yes, please.
So long as the plea can be taken, the magistrate has jurisdiction to either grant bail or not to grant bail. All right? You are only going to be denied bail if the offense you are charged with is not bailable. And in that regard, even at the High Court, you will not be granted bail. But if it is an offense that is bailable, the magistrate that is taking the plea have the authority to either decide to remand you or to release you on bail at the time of taking the plea.
Honorable Chair, there is no place in the Gambia from Khartoum to Koina where you can travel 2 days, you don't reach. There is no place in the Gambia where you can travel 2 days, the whole day, you don't reach. No. More so within that particular region where you have a high court, they should be able to travel within a day and reach the court before the end of the 72 hours elapsed. So I think competent court is definitely very good.
Respond to that. We have situations where, for example, end of this month, High Court closes. There is only one judge that's sitting. There will be no High Court in Basse for the next 2 months until October when the court resumes. Only magistrates will be sitting in the whole of the provinces. So how do you deal with capital offenses that you have within the next 2 months when the High Court is on recess? Which court are you going to arraign them?
You know,
but that's one. Two, you don't only look at travel time. You look at they need time to investigate before they charge. And assuming even there is High Court, there is a judge, you go and the judge is indisposed, he's not even at work. What are you going to do? You cannot approach a magistrate? That's what we are saying.
Yes.
So if you insist on this, it's going to create a very difficulty for law enforcement.
Yes, Honorable, you know, my fears were that usually from experience, all types of crimes are taken to magistrates to be remanded. And the magistrate is not, yes, and it's not within, yes, and the magistrates don't have jurisdiction to take up those cases. But as you said now, which it made me convinced, is that even with that, the magistrate could still release the person on bail if it is a bailable offense. Just like the competent court will have done. Yes, I think that was where the fear, because more often than not, we just see them go to the magistrate and bail refused and remanded. So we told the magistrate, so far you cannot deal with the case, you just remand the person. But they can give you bail.
Okay.
That's Where are we talking about? 30. So, Honorable Wulis, so we leave the subordinate court.
My problem is, why don't we just say court? Instead of subordinate, whichever is possible,
They get to restrict you, for instance. Under the high courts, for instance, in URR, they are on recess. They can take you to a magistrate's court, and then you will be restrained because of the nature of the crime you are alleged to have committed. But the magistrate also has the same right as the competent court to grant you bail. Yeah, but what I'm saying is, you are saying, why not we first put court? What is the difference between court and subordinate court?
it's a lower court, isn't it? It's a lower court. Huh?
Let's hear the legal. Yes, let's take that defined. Yes, no, yes.
Chair, here when we said subordinate court, compare it to the high court. The magistrate courts are called as the subordinate courts, compared to high courts and the Supreme Court. But the case that we have in hand here, before somebody is taken to the higher court, you are usually, the issue is usually at the subordinate courts. Do you understand? If a person commits crime in Wuli, before the person is taken to high court, is usually, been tried. Before you go to Supreme Court, you have to go to the courts in Basse. So the subordinate courts here, I think, is taking justice to the grassroots level. It's making our people accessible to justice. So if you take out subordinate court from here, you want to put it court, it could be any court. So we have to be specific, and you have to look at the clause itself, because the clause says bail what? Now I understand. It's about bail of a person arrested without a warrant.
You know what? What these people are fighting for? They are fighting for the accused right. Subordinate court, it means they have to release you because they cannot continue to detain. You are talking.
Honorable Speaker.
Custody of the
We concede.
Yes, if for instance, my belief then was that the subordinate courts, they don't usually grant bail. Very rare. If you are taken to the subordinate court and they are not the competent jurisdiction, they usually remand you. But so far they also have the powers to grant bail, then that's fine.
Alice, time practicable.
One of the times, whichever time.
But he said, Alice, time practicable. We remove this. You want it the other way around.
All right, honorable members, on this 34, honorable member for Woolley, your proposal was that the subordinate, I think we would leave it there, but you also made earlier submission that earliest time practicable, the time after practicable should be removed. One of the times should be removed. Yeah, I think that's noted, and the drafters will look into it. They will look at it and then remove them. Yes, sometimes it may be the earliest time practicable, sometimes it may be the earliest practicable time. The drafters will determine that. But you want one out. Yeah. Yes?
Yes. Honorable nominated member Chebaram Fofana just reminded me that I should remind you that this is a convenient time for prayers and lunch.
Why is it that the honorable nominated member could not have said it?
That's why I said he.
Why not him?
He said.
Are you the messenger?
Thank you very much, Chair. Thank you.
No, he said something which cannot be on record.
No, I told you, my maternal grandmother comes from Kiang. I don't want you to be like Jara. Please. That's why he's scared. Honorable members, we can go to 34. After 34 is part 2. We stop at 34 and go for break. Huh? So we are. It is proposed that clause 30, bail of arrest of person arrested without a warrant, stand part of the bill as amended. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 31, police to report apprehensions.
It is proposed that clause 31, police to report apprehensions, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 32, principal magistrate to visit police stations every month.
Something there. At 32.5. 32.5a.
32.5a, yes.
Where an officer in charge of a police station or an agency authorized to make arrests fails to comply with the provisions of subsection 3, the default shall be A, treated as a misconduct. So there we want to add contempt. Yes, the committee recommends to add contempt to misconduct.
Treated as
contempt
and misconduct.
Yes. I think that's the recommendation.
Which one is more severe, contempt or misconduct? Honorable Attorney General.
This more serious. I don't know why you want to raise it. I would suggest we leave it as a misconduct, let it be handled as a disciplinary matter.
Honorable member for Woolley, What is section 3? Read section 3.
An officer in charge of a police station or an agency authorized to make an arrest shall make available to the visiting principal magistrate or designated magistrate exercising his or her powers under subsection 1. Because here the magistrate is involved.
Until you finish.
Under subsection 1A, the full record of arrest and record of bail. B, applications and decisions on bail made within the period. And C, any other facility the magistrate requires to exercise his or her powers under that subsection. 4, with respect to other government agencies authorized to make an arrest, the High Court shall visit such detention facilities for the purposes provided in this section. 5, where an officer in charge of a police station or an agency authorized to make arrests fails to comply with the provisions of subsection 3.
Yeah, you know,
the default.
Yes, you are reading subsection 4. We are now only interested in subsection 3. Because subsection 5 made reference to subsection 3 only. So where a police officer fails in those A, B, and C, he said it shall be treated as misconduct. And you people are saying it should also, contempt should also be added.
A magistrate made an order for you to do A, B, C, and C, and you do not do it. Should we just take that as misconduct? If it is between the police, I can understand that, but it's now court is involved.
It said, here it said, it's not an order, an officer in charge of a police station or an agency authorized to make an arrest shall make available to the visiting principal magistrate or designated magistrate exercising his or her powers under subsection 1.
Disciplinary procedure prescribed by any law regulating the conduct of the officer or officer of the agency. So contempt can come under that.
If somebody fails to do a regular duty, in office, regular office duty, it's misconduct. So there will be disciplinary measures taken against you to remedy that situation. We find honorable, yeah, okay.
It is committed in magistrate's presence.
Pardon? So it is proposed that clause 33, offense committed in magistrate's presence, stand part of the bill. Those in favor, please say aye. Not in favor, please say no. The ayes have it.
Clause 34, arrest by magistrate.
It is proposed that clause 34, arrest by magistrate, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So, honorable members, the honorable member for Kiang West requested that he is a little bit hungry and that we should take break to re-energize ourselves. In the circumstance, honorable members, I will suspend the committee of the whole assembly and resume resume parliament. I'm going up.